Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP.
Hello, good morning po sa ating lahat ng mga local government officials who are joining today's training, and you have reached this not going to the uh, Hello, good morning po sa ating lahat ng mga local government officials who are joining today's training, and you have reached this
Recording in progress.
Hello, good morning po sa ating lahat ng mga local government officials who are joining today's training, and you have reached this far, particularly in the discussion of civil, penal, and administrative provisions, and including blacklisting procedures. So I hope that you will learn much from today's discussion and apply it as you perform your duties as procurement practitioners in your own respective local government units, okay? So there is a certain standard of ethics that government officials will have to comply with, or will have to observe, no, in relation to their duties as procurement practitioners. And not only our members of the procuring entities or procurement organizations are required to observe the highest standard of ethics, but also bidders, manufacturers, suppliers, or distributors during the procurement or at the procurement stage, and of course during the execution of the contract. And for public officials, they must all be accountable to the people and shall discharge their responsibilities, of course, with integrity, with competence, loyalty, and shall act with patriotism and justice, no? Leading modest lives and uphold the public interest over personal interest. And as I said a while ago, it is not only required for procurement organizations, but also for bidders as well. And such that bidders who have been determined to have committed such corrupt, fraudulent, collusive, coercive practices by the government will of course not be eligible to bid in its project of the government. They will not be allowed, or they will be prohibited to join government biddings, no? So ano po ba yung mga unlawful? In fact, this corruption, fraudulent and collusive and coercive practices are determined unlawful, no? Not only under the procurement law, but other laws as well. So ano po ba yung coercive practices na to, collusive practices and corrupt practices na ito, and fraudulent practices, no? So these coercive practices means that there is an intention to harm or threaten, no, directly or indirectly, the persons or even their property to influence their participation in a procurement process, or will affect the execution of the contract. So possibly ano po ba yung mga examples nito? So for example, a person or maybe a bidder, no, trying to threaten members of the Bids and Awards Committee, or maybe even members of the procurement organization, or maybe even the secretariat or the technical working group, no? Presumably, this bidder has relationship probably to the boss of the member of the procurement organization, such that, for example, technical working group yan, na he would threaten, no? The bidder would threaten that, for example, hindi niya i-award yung project sa kanya, then hindi siya mapopromote or something, or maybe even to the extent of the personal personality of the person, or the person who is in charge, or member of the procurement organization, no? So it's not allowed, or it is unlawful, no? The second one is a collusive practice, no? Collusive meaning collusion, there is collusion, although we also know that collusion is so difficult to prove. However, it means it is defined as a scheme, no? A scheme or arrangement, pwede natin sabing arrangement, including even practices, no, among bidders. And this happens prior or during the submission of bids, which are really designed to establish bid prices that are artificial, no? Artificial, ibig sabihin, kunyari, nagbibidding-bidding sila pero hindi naman. Such that it becomes non-competitive and it prevents the free and open competition as envisioned by the procurement law, no? So medyo mahirap din siya, no? So I mean, it's not allowed under the rules. The third one is the corrupt practices, meaning on the part of the bidder, he is offering, no, giving or receiving, of course, on the part of the procurement official, no, or soliciting, no, of anything of value to influence the action of public official in the selection process or during contract execution, meaning pwede niyang sabihin na okay, if you allow this project to be awarded to me, then 10% or 20% or even 25%, no? Some of those that we whether that's true or not, the practice of that corruption is proscribed. So because in terms of corrupt practices, contracts that are entered on behalf of the government or any transaction becomes manifestly and grossly disadvantage to the government, no? And this is regardless of whether or not the public official will profit from it, no? And these are also acts that are similar under RA 3019. So the act of corruption in itself, no, by offering, by bribing, is really proscribed or not allowed under the rules, no? Sorry, galaw, no? And then of course there is that fourth one for fraudulent practices where there is a misrepresentation. There is a misrepresentation of fact in order to influence the bidding process or the selection process or even the execution of the contract to the detriment of the procuring entity. So kumbaga, one example might be sinabi niya na they have experience for this type of project, but the truth is that wala naman pala siyang experience. And these are meant to influence yung bidding process, no? So let us, as public officials, we are reminded to exercise and to be wary of these unlawful acts in terms of how we perform our obligations as public officials or procurement officials, no? So these unlawful acts, of course, have certain penal, sorry, may penal provisions, no? So nakakatakot ito because we have seen or we have heard of various officials who have, been involved in such or in this type of activities, and they have suffered the consequences of their actions, no? And the sad thing is that, no, even if it's willfully or willfully done or not or nagkamali lang, there are still penal provisions that are attached to it, no? So without prejudice to the provisions of RA 3019 or Anti-Graft and Corrupt Practices Act and other penal laws, public officials who commit the acts which are enumerated in section 65.1 of the IRR, including the private officials who collude with them, no? Collude meaning nakikipagsabwatan, no? So nakikipagsabwatan yung public officials sa private officials, then they become liable under this law, no? RA 9184. The second one is private officials who commit any of the following acts that are included under section 65.2 and 65.3 of the IRR, of the revised IRR of RA 9184. And of course, public officials who conspire with them. So this will be enumerated later. And take note that this covers all types of procurement, whether done manually or electronically. So and even small value procurement or alternative modes of procurement, and much more when there is a public bidding that is to be conducted. No, um, and in terms of juridical entities, or when a bidder is a juridical entity, the criminal liability and the accessory penalties will be imposed to the directors, officers, and employees who actually commit the acts that were enumerated previously, which is the private officials colluding with private officials, or by themselves, or vice versa, private officials or public officials committing with one another or colluding with one another. So let us all be wary of these penalties, no? And if a person previously held liable or found guilty under the provisions of the Act has controlling interest in a prospective bidder entity, the said bidder entity shall be disqualified to participate in any of the government procurement activity being conducted by the government. So take note that it's not the juridical entity, not only the juridical entity, no, but the officials who will be guilty are also not allowed to participate when they are also part of the, when they are controlling interest in another corporation or another entity, which is the prospective bidder or entity, no? So ano po ba yung applicable penalty na yan? So the applicable penalty is imprisonment of 6115. So 6115, not less than 6 years and 1 day, but not more than 15 years. And for public officials, there is a temporary, or perpetual. Buti kung temporary lang, ano, perpetual meaning life for life, no? And when you're young, no, when you're young and you get this punishment, naku, where will your career be, no? So, and for private individuals, they will be permanently disqualified from transacting business with the government. Okay? So who has jurisdiction and over the offenses that are defined under the rules? So it shall belong to the appropriate courts, which are in accordance with laws at the time of the commission of the offenses. So there are offenses kasi that are applicable, or that are defined in terms of jurisdiction, or where they should be filed in these specific courts, no, or in the appropriate courts as defined by those laws, no, at the time of the commission of the offenses. So these are the laws usually define where the cases will be filed, and of course the application of the applicability of the laws would be, of course, at the time of the approval. No? Usually, hindi naman po siya prospective. So, ano po ba yung mga offenses that are committed by public officials? So, let's go one by one. And these are included under Section 65A, no, of RA 9184 and its revised IRR. So, ano po ba yun? Number one, ito po yung nag-open ng sealed bids, including but not limited to the bids that may have been submitted through electronic system. So hindi lang po siya manual, but also electronically submitted. So nag-open siya ng sealed bid because it's not allowed. It's only during the opening of bids that the time of the designated opening of bids that the bid should be open. It's not prior, no? And of course, delaying with a justifiable cause the screening for eligibility, no, the opening of bids, the evaluation, the bid evaluation, and the post-evaluation of bids, and even awarding of the contracts, which are usually or which will be beyond the prescribed period of action that is defined under the rules, no? So kailangan dapat ang evaluation or post-qualification should be maximum of 45 days, no? Under exceptional circumstances. And if, for example, without justifiable cause, extend ng hindi naman within the rules, then there could be a liability attached to it. Of course, it's specified that it's without justifiable cause. Kung justifiable cause naman siya, for example, na COVID naman yung tao, no? Or other, instances that might have prevented the conduct of those actions or procurement actions within the allowable period, then it's covered under section as an offense under this section. The next one would be unduly influencing or exerting undue pressure on any member of the bank or any official or any employee of the procuring entity. So ito parang namimilit siya, no? Minsan nananakot pa. Minsan sasabihin pa nila na otherwise cases will be filed against you, no? May ganun pa sila minsan based on experience, no? And if of course kung naman alam mo naman natin yung bidder sometimes, no, they also insist on what they believe in. So as long as there is an undue influence or undue pressure that is pressed on to any member of the procurement organization, then it could be an offense under this rule, no? The pangilan na yun. The third one or the fourth one is the splitting of contracts. So yung splitting of contracts is as a general rule, no? As a general rule is not allowed. Ito po yung artificial breaking down of contracts which is with the intention of circumventing the procurement law, as in, for example, for competitive bidding, dapat po 2 million siya and then it goes to public bidding. But then, because there is an intention to circumvent the rules, ginawa nilang tigpa 500,000, no? Just to artificially phase out or phase the projects for purposes of circumventing the public procurement or yung default mode of public bidding. And so these are not allowed. And even for example, you do splitting of contracts just to split the signatories, for example, as in, for example, you have general memorandum orders that define the authority, no, of certain officials, like for example, the head and then the deputy, and then intentionally they divide it into phases for purposes na mapunta siya sa isang deputy, not going to the head of the procuring or head of the entity, just so they would phase it artificially for purposes of maybe evading some authorities. So these are not allowed. And then the sixth one is when there is an abuse in the exercise of his power to reject any and all bids. So this could probably be related to section 41, which is the reservation clause, no? Where there is an abuse of this power. Because remember that the head of agency is the only one that can exercise the reservation clause. And by this, when he abuses his authority, like for example, he would ayaw talaga niya yung bidder for no cause at all, no? For no cause at all, then ayaw lang talaga niya yung bidder na yan, or maybe he has grudges to the bidder na yan in the past, no? Personally or otherwise, then it becomes an offense that is committed by the public official. No? Okay. So what about private individuals? Ano po ba yung offenses naman that are committed private individuals? So the first one is the agreement or agreement to submit bids with pre-arranged lowest bidder. So for example, may dalawang bidders, they artificially or they agree that parang artificial competition on their part, no? That ikaw ito, ako ito, magsasabit ako ng ganito, ako naman yung mananalo ngayon. Ano? Ako naman yung mananalo ngayon, ikaw na naman sa susunod. So sila, nag-agree na sila on the bids that will be placed there such that their bids are, ang difference lang siguro nila, mga pesos lang, for example. And yung lowest bid would be na mataas pa rin yung presyo, no? So pre-arrange po, nag-usap-usap na sila. And then the second one is the malicious submission of different bids through two or more persons. It's the same thing, no? Pwedeng yung bidder A example, may dalawang bidders, they artificially or they agree that parang artificial competition on their part, no? That ikaw ito, ako ito, magsasabit ako ng ganito, ako naman yung mananalo ngayon. Ano? Ako naman yung mananalo ngayon, ikaw na naman sa susunod. So sila, nag-agree na sila on the bids that will be placed there such that their bids are, ang difference lang siguro nila, mga pesos lang, for example. And yung lowest bid would be na mataas pa rin yung presyo, no? So pre-arrange po, nag-usap-usap na sila. And then the second one is the malicious submission of different bids through two or more persons. It's the same thing, no? Pwedeng yung bidder A or they agree that parang artificial competition on their part, no? That ikaw ito, ako ito, magsasabit ako ng ganito, ako naman yung mananalo ngayon. Ano? Ako naman yung mananalo ngayon, ikaw na naman sa susunod. So sila, nag-agree na sila on the bids that will be placed there such that their bids are, ang difference lang siguro nila, mga pesos lang, for example. And yung lowest bid would be na mataas pa rin yung presyo, no? So pre-arrange po, nag-usap-usap na sila. And then the second one is the malicious submission of different bids through two or more persons. It's the same thing, no? Pwedeng yung bidder A
All right. Before at this point, before we wait as we wait for everything to settle and as we proceed with our discussion, quick reminders lang din po, no. For questions related to our learning session, please let us know through our comment section and of course through our chat box. So again po, we would like to thank everyone for bearing with us as we address po these technical challenges, especially po nga that we are now in the online training era. No? But rest assured po that we are exhausting all means to provide you not just in-depth set of sessions, but a smooth sailing program as well. We also posted the link to our presentation material so that all of you can follow through our discussion as well. But for those who were not able to catch that, sa mga siguro sa mga kakapasok pa lang, we will be posting as well. We'll be floating the link in our chat box for you to be able to follow through. All right. So again, for questions, please let us know through the chat box and or comment section. Quick shout out po again at our Facebook live viewers. I'm seeing Ma'am or Sir Astroni Manalo. Good morning, sir, from LGU Paris, Quezon. We also have, I see you, sir, just Dada Dones. Hello, good morning, sir. Thank you for joining us today. You are from LGU Paris, Quezon as well. Again, let me know po through the comment section your LGU name so that I can acknowledge you for joining us today, all right? You can also tag or share our live streaming para naman po your colleagues can also join us in our learning session for today. So I guess, are we all ready? Are we ready to proceed? And again, if you have any more concerns, please let us know through direct messages po. We are ready to assist you accordingly. Right, so let us please stand by and see you in a short while. Thank you.
Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
Or sasabihin niya na, since ganito, ikaw na mag-withdraw ka na lang, di ba? They attended both the pre-bid conference and then nag-agree sila and then i-withdraw na lang niya yung bid niya if it was submitted um, or uh, yeah, if the bid was submitted, no, or anything that would secure that there was an advantage of one over the other such that alam na nila kung sino yung mananalo, no. Okay. The next one is when the bidder maliciously submit different bids through two or more persons or corporations or partnership um, or any other business entity in which he has interest to create the impression or the appearance of competition when it does not in fact exist so as to adjudge as the winning bidder. So for example, gumamit sila ng dalawang tao rin as I have explained a while ago in the offense in the other offenses that are um, the other offenses that are to be committed, then this scheme is intended to create the appearance of competition. So, gamitan pa rin ito ng mga pangalan, di ba? Dalawang bids ang nasubmit, may isa pa nga dyan. Sinubmit niya, nagsubmit siya, and then yung person na yun has also joint venture with other corporation, no? Or other officials, or other corporations. So, although these are considered alternative bids under the rules or under the PBD, no? And what's important here is that there is a malicious intent, no, to create the appearance of competition when in fact there was none. There was none. Okay. The next one is that when a bidder or by himself or in connivance with others employs schemes which tend to restrain natural rivalry of the parties or operates to, stifle or suppress competition and thus produce a result which is disadvantageous to the government. Of course, when there is always a connivance in terms of price, no? In terms of, meron pa nga yung iba dyan, no? Magpupunit ng mga dokumento, no? And when you have that, makikita mo, may naiwan na remains, no? May naiwan na parte nung bid na yun or yung page na yun na tinanggal because 'di ba nakikonnive nga siya nakikonnive siya para manalo yung isa, no? So these are examples of really very very unscrupulous practices of some people or some private individuals. And then of course under 65C is the submission of eligibility requirements containing false information or falsified documents or concealment of such information. I have come across one bidding where, pineke niya yung kanyang tax clearance. No? So yun, very, very classic example na it appears na nagsubmit siya ng tax clearance that is valid, pero sa totoo lang, hindi naman pala siya valid. No? Nung verify namin with the BIR before, sabi niya wala naman daw siyang na-issue ganun na tax clearance. Of course, now, it's very, very easy. No? It's very, very easy to verify kasi nandyan naman sa website lahat yan ng BIR. No? And really, these are the things that you have to do, ensuring that the documents are true and correct, which can be done through post-qualification. The other one is the using of name or allowing another to use one's name, which is very common, no? Very common for ang experience ko dito, mga infrastructure project na hindi naman, we were not able to prove it, but it's been a common practice, no? Informally, they discuss among themselves, no? They discuss and makikita mo naman because one of the red flag is that wala namang tao yung ano na yun, yung contractor na yun or yung business na yun, no? Ang nagpo-provide iba, nagka-capital iba. makikita mo hindi na nga siya pumupunta, hindi niya tinitignan ano, yung project na yun. So these are indications of them allowing their names to be used by another person. Then the next one is the submission of bidding documents containing false information or falsified documents or concealment of such information. Also, ang example nito, sabi ko nga, is the SLCC, no? The technical documents that were submitted in support to the bids that are being procured by the agency. One experience that we had is some people or some contractors yung pinipeke nila yung title of the project, no? And we have discovered that some projects in areas, in some of the foreign assisted projects that we had, and we verified with the proper government agency, no, who really undertook the project or completed the project, and we were able to discover na ginamit lang talaga, no, or pinatungan yung mga documents na yan. So that is the use of your post qualification. Of course, yung withdrawal of the bid of course, yung withdrawal of the bid is not 100% naman an offense, no? For example, kung yung withdrawal of the bid naman has some reasons, valid reasons, as in, for example, ang nakita ko dito na ganito, yung may namatay yung proprietor, and then and as a reason hindi na nila maasikaso, so the officials, they withdrew the bid of that company where the owner has died. So those are examples of justifiable, pero hindi naman din 100%. Sabi ko nga na yung pag-withdraw ng bid ay offense in itself, no? The other liability is the civil liability, no? And without prejudice to administrative sanctions that may be imposed in proper cases, a conviction under RA 9184 and RA 3019 shall carry with it the civil liability. So you hear this usually, that sinasabi nila in criminal cases, there is always a civil liability, or there is a civil liability that is involved, no? And this may consist in the restitution of the damage done. No? Ibig sabihin, ibalik niya, restitution, di ba? Ibalik niya yung damage na yan, or iayos niya. And the second,
All right, thank you very much, Attorney Jen. At this point, we reached, I believe, our first knowledge check question for today. So again, we will be flashing our knowledge check questions through the Zoom polling feature, and all we have to do is choose the appropriate answer in the pop-up poll that shall be flashed in our screens. All right, so the question is, Republic Act number 3019 is otherwise known as the letter A, Government Procurement Reform Act, letter B, Anti-Graft and Corrupt Practices Act, or letter C, Anti-Red Tape Act. Ayan. Again, the question is, Republic Act number 3019 is otherwise known as the letter A, Government Procurement Reform Act, letter B, Anti-Graft and Corrupt Practices Act and other penal laws, or letter C, Anti-Red Tape Act. Again, please answer through our Zoom polling feature. That's for our Zoom official participants. And of course, our Facebook and YouTube Live viewers, please join us and kindly answer through our comment section. I'm seeing Ma'am Ten and Ma'am Alma. They answered letter B. While in our Zoom box, I'm seeing 75% participation I'm hoping to have 100% participation po today because again, this is a requirement for you to receive your certificates. So please join na po our knowledge check portions. If you are having difficulties answering through our Zoom polling, please let us know through our Zoom chat box. Okay. Yan. Tumas po, we have 81% participation as of the moment. Sige, I will be closing po the Zoom poll in a while. Let's give more time po for others to answer. Alright, so I guess we can close it now in 5, 4, 3, 2, and 1. Alright, so we have 93% who answered letter B, while 7% who answered letter A. Good morning, Attorney Jen. Tama po bang majority?
Yes, Miss Monique, good morning to everyone. Tama po yung kanilang sagot, letter B. Kasi po yung letter A is RA 9184, of course, and then yung letter C is RA 11032. So good morning po sa ating lahat.
Alright, thank you very much, Attorney. So again, the correct answer is letter B. Republic Act number 3019 is otherwise known as the Anti-Graft and Corrupt Practices Act and other penal laws. Alright, so we may now proceed po with the lecture discussion. Back to you, Attorney.
The other liability is the civil liability, no? And without prejudice to administrative sanctions that may be imposed in proper cases, a conviction under RA 9184 and RA 3019 shall carry with it the civil liability. So you hear this usually that sinasabi nila in criminal cases, there is always a civil liability or there is a civil liability that is involved, no? And this may consist in the restitution of the damage done. No? Ibig sabihin, ibalik niya, restitution, di ba? Ibalik niya yung damage na yan or iayos niya. And the second one would be the forfeiture in favor of the government of any unwarranted benefit which is derived from the acts in question or both at the discretion of the court. As in, for example, there was an identification of the there was an identification of the what do you call this? The money that was put in the bank. So yan, pwede rin yan, ano. Okay? So, ano naman po yung administrative sanctions? Administrative sanctions naman, of course, this is in addition to civil liability and penal sanctions, no? Which the hope, subject to the authority delegated to the BAC, shall impose, no, on bidders or prospective bidders some administrative penalty. So si Hope, no, can sanction the bidders or prospective bidders. And these are number one, pwedeng suspension siya for the first offense. And second, uh, 2 years for the second offense from participating in public bidding process, and disqualification from further participating in public bidding being undertaken by the procuring entity, no? So yan. The second one is forfeiture of bid security or performance security. So ito po yung bid security. Of course, it can be form of bid security declaration, no? Pwede siyang surety bond, cash, cashier's check, manager's check. So for performance security man naman, ito yung performance security declaration. The same then, which is provided under the rules, which is surety bond, cash, no? Sorry, cashier's check or manager's check. So the procedures for blacklisting of manufacturers, suppliers, distributors, contractors, or consultants for government projects shall be undertaken in accordance with the guidelines which are issued by GPPB pursuant to GPPB Resolution 40-2017. And this is pursuant also to Section 69.4 of the revised IRR of RA. So, ano naman po? So, the termination of contract is covered by GPPB Resolution 17-2019, no? And this has been made effective last May 9, May 4 of 2019. So ano po ba yung possible na grounds for termination of contracts? So, these are 5, no? By default, convenience, insolvency, unlawful acts, and termination by contractor or consultant. So we will discuss it one by one, no? For termination by default, so the procuring entity shall terminate a contract when any of the following conditions attend its implementation, no? So for goods, no, when there is an outside force majeure where the supplier fails to perform or deliver, no, any and all of the goods wherein such failure amounts to 10% of the contract price. So if the failure to perform consists of a non-delivery or non-performance of at least contract price, 10% of the contract price, then it is considered possible ground, no, for termination. And then secondly, as a result of force majeure, hindi nakadeliver si supplier doon sa goods of at least 10% of the contract price for a period of not less than 60 days after the receipt of notice that the force majeure is deemed to have ceased. So for example, no, may force majeure, and then nag-notice tayo sa kanya, sinabi natin that he has to submit or he has to comply with the conditions of or the contract wherein he is to perform, but he failed to perform at least 10% of the contract after such notice for a period of not less than 60 days, no? 60 calendar days. So, kung sakaling hindi siya nakapag-comply after such notice and after the cessation of the force majeure, then there is also a ground for termination by default or for default. And then, of course, the failure of the contractor or the supplier to perform any other obligations under the contract. So this is for goods in any of that condition, no? And then for contracts naman for infrastructure project, due to the contractor's fault and while the project is ongoing, it has incurred a negative slippage of 15% or more. So 15% or more kapag infra, where the project is ongoing, may negative slippage, no, with the fault of the contractor. So the other one is after expiration of the contract time, may negative slippage of 10% or more due to his own fault. So, for example, yung kontrata na nag-end naman June 30, no? And then the contractor, July 31 or onwards, incurred 10% slippage or more due to his own fault, then there is there is a ground for terminating the contract for default of the contractor. And then, if the contractor commits any or all of the following, like for example, he abandons the contract works, or he refuses or fails to comply with the valid instruction of the procuring entity, no? Like for example, yung sinasabi natin kanina, dinidiscuss natin kanina, there is an instruction to put up safety notices, no? Secondly, yung adding up the equipment. Pag ano niya, dapat ho dagdagan niya yung equipment per contract dahil hindi naman ho niya kino-comply yung conditions that was part of his bidding document yan, and he fails to proceed expeditiously and without delay despite such written notice, then he will still be liable for this, no? And then he does not have the listed minimum essential equipment in the project site in accordance with the approved work plan and deployment schedule as probably submitted during the bidding or any revision thereto, no? And then thirdly, under this condition, when he does not execute the works in accordance with the contract. So hindi niya ginagawa yung obligasyon niya under the contract, he neglects to carry its contractual obligations. Like for example, dapat po na-finish niya po ito, yung fences niya, for example, or structures, then ay hindi niya ma-execute yung mga yun, then he commits also this one. And then fourth, he neglects or refuses to remove materials or perform a new work that has been rejected as a result of defective or unsuitable contracts, no? Unsuitable works, no? So for example, nakita na determined that he has to remove and replace certain items there for infrastructure project, pero ayaw niya. And then nagpasugpon siya without any approval by the procuring entity. So dapat po kumukuha siya ng approval, no? Under the rules. For consulting services naman, no? Outside of force majeure, so walang force majeure under normal condition, he fails to deliver the outputs within the contract. As in, for example, dapat within 60 days yan, hindi naman yan nakakomply, no? Because of certain, of his fault, no? And then if it's a result naman of force majeure, dapat ho ganun din. Like for example, as in, for example, sa goods din, and he is unable to perform yung material portion of the outputs, no? Dapat ho kasi nagbibigay ng notice sa procuring entity upon the cessation of the force majeure. And if he is able to, is unable to deliver for a period of not less than 60 calendar days, then can be terminated also, no? And then the consultant fails to perform any of the obligations under the contract. The second type of termination is the termination for convenience. Like for example, the procuring entity may terminate the contract at any time at its convenience. Like for example, if it has determined that the project would no longer be economically, financially, technically, and impractical, no, and unnecessary. So for example, no, there are certain conditions that has affected the feasibility of the project, no? Yan, pwede naman siyang terminate by convenience. The other one is termination for insolvency. For example, and in these cases, the procuring entity shall terminate the contract if na bankrupt siya, no? It has been declared as insolvent and has been determined with finality by the court of competent jurisdiction. So naman order na paano naman niya magagawa yun kapag talaga namang nag-bankrupt siya or naging insolvent siya. And then the bankruptcy or the insolvency of the supplier or contractor or consultant must have been determined by the court of competent jurisdiction. So, hindi man pwedeng basta sabihin niya na insolvent ako, hindi po pwedeng ganun. And then termination without compensation provided such that such termination will not prejudice any right of action or remedy which has accrued or will accrue thereafter. So, yan, pagka termination is without compensation, no? Provided yung termination, walang maaapektuhan, no? It will not prejudice or any right of action or remedy which has accrued or will accrue thereafter, no? And if termination by unlawful acts naman, the procuring entity may terminate the contract in case it is determined prima facie that the supplier has engaged during or before the implementation of the contract in unlawful deeds and behaviors relative to contract acquisition or implementation. So, even if it has been determined na unlawful naman talaga yung pagkuha niya doon sa kontrata na yun, by one reason or another, it has been determined that there were illegal, unlawful deeds that were done, then it can be a reason for termination because of that unlawful acts, no? So, ano po yung example nito? Yung unlawful acts will include corrupt, fraudulent, collusive, and coercive practices. So, for example, yung controlling interest, controlling shareholders in common with another bidder. So, na-determine na pareho pala na pag-aari siya or controlling interest siya to a certain bidder din. It has been determined as such, no? And then the bidder receives or receive any direct or indirect subsidy from another bidder. Forged documents, possible din yan na a reason, no? Ayan, the same legal representative sila, no? It's one of those red flags talaga na hindi mo ma-determine agad-agad. And the bidder has, relationship with common third parties that may provide information or influence the bid of another bidder. So these are examples of unlawful act that can cause the termination of the contract by reason of unlawful acts. Yun. So very, very important. It does not relieve even if it's contracted out, no? If it has been determined that there has been happening of these unlawful acts, then it can be terminated. So what about the contractor or consultant terminating by himself? No? If for construction projects, so for infrastructure project, the contractor may terminate his contract with the procuring entity if the works are completely stopped for a continuous period of at least 60 days through no fault of his own. So 60 days continuously na-stop, na wala naman siyang kasalanan. And then failure of the procuring entity to deliver the supplies, yung materials, if there are such in the contract, no, as a matter of obligation, no, right of way kung sakali may problem wala or other items under the terms of contract. And then the work is disrupted by adverse peace and order situation as certified by the AFP, no, and approved by the Secretary of Defense. So what about consulting services? So the consultant may terminate its agreement with the procuring entity if the latter is in material breach of its contractual obligations and has not remedied yung the same within 60 days from the receipt of the consultant's notice specifying yung breach na yan. So, very important that if there is also a material breach on the part of the possibly because of the agreement in relation to agreement with the procuring entity, if there is a material breach of the procuring entity, then it could be a reason. Like for example, di ba hindi yung pagbibigay niya, yung kanyang isusupply niya dapat na office, di ba? Tapos hindi naman yan binigay. So hindi niya sinuportahan. So it can be a reason for termination. And it should be noted that the consultant should notify yung type of breach na yan to the procuring entity.
Thank you very much, Attorney. For our second knowledge check question, kindly answer again in the pop-up poll that shall be flashed in our screens. And the question is, the PE cannot terminate the contract at any time for its convenience. Is this true or false? Again, the question is, the PE cannot terminate the contract at any time for its convenience. Is this true or false? Quick reminder po again, if you have questions, please drop them in through our Zoom chat box. We also have Billy Bayong noting all your questions po in the comment section of our live streaming. So comment down below po for your questions or concerns. I'm seeing 51% participation in our Zoom box. How about in our comment section? Again po, the question is, the PE cannot terminate the contract at any time for its convenience. Is this true or false? I'm seeing 62% participation. I'll be closing the call in 5, 4, 3, 2, and 1. Ayan, humabol po. Hi, good morning, Ma'am Alma. Thank you for joining our call question. Who answered true, while 35% who answered false. Hi, Attorney. Tama po ba ang majority?
Hello, ang tamang sagot ay false. The PE can terminate the contract at any time for its convenience, parang 35%, no?
Yes.
Especially if it has determined that the project is already, economically, financially, and technically impractical or unnecessary. So, ilan ang tumama sa inyo? 35%. At least now you know that the procuring entity can really terminate the contract. It has determined, no, that the project is economically, financially, and technically impractical or unnecessary.
Thank you very much, Attorney. Baka nalito lang po, no? But again, please do take note that the correct answer is false. So at this point po, we are now to proceed with the final part of our lecture discussion under our first learning session for today. So back to you, Attorney.
So the termination of contract is covered by GPPB Resolution 17-2019, no? And this has been made effective last May 4 of 2019. So ano po ba yung possible na grounds for termination of contracts? So these are 5, no? By default, convenience, insolvency, unlawful acts, and termination by contractor or consultant. So we will discuss it one by one. No? For termination by default, so the procuring entity shall terminate a contract when any of the following conditions attend its implementation. No? So for goods, no, when there is an outside force majeure where the supplier fails to perform or deliver, no, any and all of the goods wherein such failure amounts to 10% of the contract price. So if the failure to perform consists of a non-delivery or non-performance of at least contract price, 10% of the contract price, then it is considered possible ground, no, for termination. And then secondly, as a result of force majeure, hindi naka-deliver si supplier doon sa goods of at least 10% of the contract price for a period of not less than 60 days after the receipt of notice that the force majeure is deemed to have ceased. So for example, no, may force majeure, and then nag-notice tayo sa kanya, sinabi natin that he has to submit or he has to comply with the conditions of or the contract wherein he is to perform, but he failed to perform at least 10% of the contract after such notice for a period of not less than 60 days, no? 60 calendar days. So, kung sakaling hindi siya nakapag-comply after such notice and after the cessation of the force majeure, then there is also a ground for termination by default or for default. And then of course, the failure of the contractor or the supplier to perform any other obligations under the contract. So this is for goods in any of that condition, no? And then for contracts naman for infrastructure project, due to the contractor's fault and while the project is ongoing, it has incurred a negative slippage of 15% or more. So 15% or more kapag infra where the project is ongoing, may negative slippage, no? With the fault of the contractor. So the other one is after expiration of the contract time, may negative slippage of 10% or more due to his own fault. So, for example, yung kontrata na nag-end naman June 30, no? And then the contractor, July 31 or onwards, incurred 10% slippage or more due to his own fault, then there is there is a ground for terminating the contract for default of the contractor. And then, if the contractor commits any or all of the following, like for example, he abandons the contract works, or he refuses or fails to comply with the valid instruction of the procuring entity, no? Like for example, yung sinasabi natin kanina, dinidiscuss natin kanina, there is an instruction to put up safety notices, no? Secondly, yung adding up the equipment. Pag dapat ho dagdagan niya yung equipment per contract dahil hindi naman ho niya kino-comply yung conditions that was part of his bidding document yan, and he fails to proceed expeditiously and without delay despite such written notice, then he will still be liable for this, no? And then he does not have the listed minimum essential equipment in the project site in accordance with the approved work plan and deployment schedule as probably submitted during the bidding or any revision thereto, no? And then thirdly, under this condition, when he does not execute the works in accordance with the contract. So hindi niya ginagawa yung obligasyon niya under the contract, he neglects to carry its contractual obligations. Like for example, dapat po na-finish niya po ito, yung fences niya, for example, or structures, then ay hindi niya ma-execute yung mga yun, then he commits also this one. And then fourth, he neglects or refuses to remove materials or perform a new work that has been rejected as a result of defective or unsuitable contracts, no? Unsuitable works, no? So for example, nakita na determined that he has to remove and replace certain items there for infrastructure project, pero ayaw niya. and then nagpasubkon siya without any approval by the procuring entity. So dapat po kumukuha siya ng approval, no, under the rules. For consulting services naman, no, outside of force majeure, so walang force majeure under normal condition, he fails to deliver the outputs within the contract. As in, for example, dapat within 60 days yan, hindi naman yan nakakomply, no, because of certain because of his fault, no. And then if it's a result naman of force majeure, dapat ho ganun din. Like for example, as in, for example, sa goods din, and he is unable to perform yung material portion of the outputs, no? Dapat ho kasi nagbibigay ng notice sa procuring entity upon the cessation of the force majeure. And if he is able to, is unable to deliver for a period of not less than 60 calendar days, then can be terminated also, no? And then the consultant fails to perform any of the obligations under the contract. The second type of termination is the termination for convenience. Like for example, the procuring entity may terminate the contract at any time at its convenience. Like for example, if it has determined that the project would no longer be economically, financially, technically, and impractical, no, and unnecessary. So for example, no, there are certain conditions that has affected the feasibility of the project, no? Yan, pwede naman siyang terminate by convenience. The other one is termination for insolvency. For example, and in these cases, the procuring entity shall terminate the contract if na bankrupt siya, no? It has been declared as insolvent and has been determined with finality by the court of competent jurisdiction. So may order na paano naman niya magagawa yun kapag talaga namang na-bankrupt siya or naging insolvent siya. And then the bankruptcy or the insolvency of the supplier or contractor or consultant must have been determined by the court of competent jurisdiction. So, hindi man pwedeng basta sabihin niya na insolvent ako, hindi po pwedeng ganun. And then termination without compensation, provided such that such termination will not prejudice any right of action or remedy which has accrued or will accrue thereafter. So, yan, pagka termination is without compensation, no? Provided yung termination, walang maaapektuhan, no? It will not prejudice or any right of action or remedy which has accrued or will accrue thereafter, no? And if termination by unlawful acts naman, the procuring entity may terminate the contract in case it is determined prima facie that the supplier has engaged during or before the implementation of the contract in unlawful deeds and behaviors relative to contract acquisition or implementation. So, even if it has been determined na unlawful naman talaga yung pagkuha niya doon sa kontrata na yun, by one reason or another, it has been determined that there were illegal, unlawful deeds that were done, then it can be a reason for termination because of that unlawful acts, no? So ano po yung example nito? Yung unlawful acts will include corrupt, fraudulent, collusive, and coercive practices. So for example, yung controlling interest, controlling shareholders in common with another bidder. So na-determine na pareho pala na pag-aari siya or controlling interest siya to a certain bidder din. It has been determined as such, no? And then the bidder receives or receive any direct or indirect subsidy from another bidder. Forged documents, possible din yan na reason, no? Yeah, the same legal representative sila, no? It's one of those red flags talaga na hindi mo ma-determine agad-agad. And the bidder has, relationship with common third parties that may provide information or influence the bid of another bidder. So these are examples of unlawful act that can cause the termination of the contract by reason of unlawful acts. Um, Yun. So very, very important, even if it's contracted out, no? If it has been determined that there has been happening of these unlawful acts, then it can be terminated. So what about the contractor or consultant terminating by himself? No? If uh, if for construction projects, so for infrastructure project, the contractor may terminate his contract with the procuring entity if the works are completely stopped for a continuous period of at least 60 days through no fault of his own. So 60 days continuously na-stop, na wala naman siyang kasalanan. And then uh, failure of the procuring entity to deliver the supplies, yung materials, if there are such in the contract, no, as a matter of obligation, no, right of way kung sakali, well, no problem pala, or other items under the terms of contract. And then the work is disrupted by adverse peace and order situation, as certified by the AFP, no, and approved by the Secretary of Defense. So what about consulting services? So the consultant for termination of contract. So ito po yung verification, no? And with such notice, no, there is such a written notice of the acts, no, which may constitute kung ano yung breach na yan, ano mo yung i-terminate na yan, no? And then with all the relevant evidences that are attached to it, no, to the verification or to the verified report. And then the second is the notice to terminate, which is done upon recommendation of usually the implementing unit, no, where the procuring entity will now terminate by written notice, conveying doon na it's terminated, and what is the extent of the termination. Of course, when the contract is terminated, the acts should have been included as part of, or the acts that would constitute the grounds which should have been included. And the extent of the termination, whether is it whole, is it in part, no? And then with the instruction to the winning supplier or consultant to show cause why the contract should not be terminated, no? And then, of course, the notice to terminate should also accompany or should be accompanied by the verified report, no? And then also the show cause as a third step, no? And then where within 7 calendar days from from receipt, no, of the notice of termination, the supplier or the contractor will submit now the verified position paper stating why the contract should not be terminated, and it will show, no, it will show cause dapat, or i-explain niya kung bakit hindi siya dapat ma-terminate yung kontrata. And this should be done or should be submitted within 7 calendar days or 7 days, so that otherwise, if there is an inaction, then it would be terminated yung kontrata, no? And then there is now the rescission of the notice of termination just in case i-withdraw yan ni procuring entity, no? If it is determined that, some items or works has been completed pala, there has been delivery, there has been performance, no? Before the receipt of the notice of the supplier. So hindi pala, akala nila hindi pala natapos, yun pala natapos. And then, of course, the last one is the decision where within a non-extendable period of 10 days from receipt of the verified position paper, the Hope shall decide whether or not to terminate the contract. And the Hope shall serve the written notice of its decision, and unless otherwise provided, the contract is deemed terminated from the receipt of the Hope's decision. So if you notice, no, upon receipt niya yan, wala pa siyang aantayin na number of days, no? And of course, the termination shall be based on the grounds that are stated in the notice to terminate. So hindi pa siya pwedeng magsasabi na ito yung notice of termination pero iba ba yung reason doon sa decision. Okay? So yan, very briefly, I have discussed 7 days where there is a submission of the verified report, no? Dapat ito, it will state talaga yung mga reasons why it's being recommended for termination. And then the notice of termination, yung sinabi ko kanina, where written notice naman ito na ibibigay, stating all the facts, the extent, the instruction, or any other special instructions, if any. And then, pwede namang i-withdraw ni procuring entity yung notice to terminate, except that it should be based on there is a determination of whether or not there has been completion, delivery, or performance. And then, of course, the show cause where the verified position paper should be submitted within 7 days upon receipt of the notice of termination. Otherwise, SICOG would issue the order of termination. Okay, and then the decision where within a non-extendable period of 10 calendar days from receipt of the verified position paper, the HOPE shall decide whether or not to terminate the contract. The failure of the supplier to submit the verified position paper within the reglementary period of 10 days, no, shall cause the issuance of the order of termination. And kapag na-receive na niya yon, the order becomes final. Of course, in aid of assisting the HOPE to decide, no, a contract termination review committee may be created by him to assist him in the discharge of his functions. And all decisions or findings are subject to the approval of the HOPE. If the procuring entity terminates the contract due to fault or insolvency or for a cause, it may enter, of course, into a negotiated procurement as an alternative mode of procurement under 53C of the revised IRR of RA 9184, where pwedeng i-take over yung contract na yan, no? Pero hindi naman ho lahat ay pwedeng ma-take over. Like for example, kung termination by convenience na talagang it has been determined to be financially or technically not feasible anymore. So, yun. Okay? So, in section 53.3, no, it provides for the procedures in conducting the negotiation. So, ang sabi dito, the contract may be negotiated by starting with the second lowest, no? So, ito yung pinaka-lowest dati na nanalo. You start now with the second lowest at the bidder's original bid price, no? Kung mag-fail yung negotiation, it shall be done with the, pupunta ka na naman sa third lowest at its original price. Kung negotiation fails again, until, di ba, kung natapos na sila, tapos wala na talagang may gusto, a short list of at least 3 eligible contractors shall be invited to submit their bids. So, pwede mo silang i-invite to submit, and negotiation shall be made starting with the lowest calculated or highest rated bidder, for example, for consulting services. Of course, this is with the assumption that the funds are still valid, no? Para or meron ka pa rin fund just in case hindi na valid yung fund na yan. The authority to negotiate contracts for projects under those exceptional cases shall be subject, of course, to prior approval of the heads of the procuring entity in consideration of their approving authority. Take note, of course, that when we do negotiation, di ba, i-deduct pa rin natin yung mga natapos na, di ba? Alangan namang bayaran pa rin natin yung hindi, ay, o yung natapos na. Okay? And then, in case for termination for convenience, and which is applicable only to goods, there is an option in termination for convenience where the goods shall be accepted if performed, no, or ready for delivery within 30 calendar days after receipt of the supplier's notice to terminate at contract terms and prices. So, pwede namang tanggapin kung sakaling ready for delivery or perform na siya. So kung hindi naman siya na-perform or not yet ready for delivery, the procuring entity may elect to have any portion delivered or performed or paid at the contract terms and prices, and or you cancel yung remaining and pay the supplier an agreed amount of that was partially completed or performed for materials and parts that has been previously procured by the supplier. So this is the termination for convenience. Depende naman yan if at fault, di ba? Kasi syempre, dideduct pa rin nila yung mga liquidated damages, mga ganyan. So the notice by the contractor or consultant, no? Of course, this is very important because it must be served to the procuring entity at least 30 days before its intended termination. And the contract is deemed terminated if it is not resumed in 30 days after such notice by the procuring. Okay, so with this, we have already completed our discussions in this blacklisting and then the penal, administrative, and civil sanctions or liability. So thank you very much. God bless po sa ating lahat.
Alright, thank you very much, Attorney. But before we officially end our learning session number 1, I believe we still have our third and last knowledge check question under this session. Alright? So for this question, again, a kindly answer through our Zoom polling feature. And the question is, in this procedure for termination of contracts, a verified position paper shall be submitted by the supplier, contractor, consultant to the HOPE within 7 calendar days from receipt of the notice of termination. Letter A, verification. Letter B, notice to terminate. Letter C, show cause. Letter D, rescission of the notice of termination. Or letter E, decision. Again, the question is, in this procedure for termination of contracts, a verified position paper shall be submitted by the supplier, contractor, or consultant to the HOPE within 7 calendar days from receipt of the notice of termination. Is this letter A, B, C, D, or E? I'm seeing 37% participation po in our Zoom box. Ayan, reminder po again, no, in preparation to our surprise knowledge check question, kindly rename using the required format. And again, that is your LGU name _ your full name for you to qualify po as our knowledge check winner. Last chance na po to score GPP BTSO special token. Kaya please rename na po to your Zoom names and follow our correct Zoom name format. And I see answers po in our comment section. Hello, good morning, Ma'am Alma Balmes from San Victor, Tanawan, Leyte. Thank you very much, ma'am, for joining us today. All right, I'm seeing 50% participation in our Zoom box. How about the others? I'll be closing the call in 5, 4, 3, 2, and 1. All right. So we have 44% who answered letter C. May tie po tayo, both 22% who answered letter A and B, while tie rin po 6% who answered letter D. Hi, attorney. May we know po the correct answer for this question?
Hello again. The correct answer is letter C. 44%. So marami naman po. If you notice, yung A, B, C, D, and E are the steps in terms of termination. And at this stage, sa verification, ito po yung pagbibigay ng facts And from the facts, they will now determine if they will now give him a notice that that they will terminate the contract, and then the show cause is where the portion where the supplier or the contractor will now submit the verified position paper why he should not be terminated. So the answer is letter C. Congratulations po. At least ngayon alam nyo na po na doon sa stage ng show cause where the supplier or the contractor will submit the verified position paper. Okay na po ba?
Thank you very much. Correct answer is letter C. Show cause. All right. So that ends our discussion proper under first learning session for today. Now, before we proceed to our second and final learning session of our program, let us first have a quick break. So please stay with us and see you in a short while. I hope everyone is back for more quick guide in government procurement and other related short videos and audiovisual presentation. You may visit our official website at www.gppb.gov.ph. At this juncture, we are down to the second and final learning session of our program. So to discuss and share her expertise on protest mechanisms and remedies and blacklisting guidelines, once again, let us have our resource speaker, Attorney Jeneline Maleteo Dawayan. While we wait for attorney and the presentation material to settle, I would like to remind again everyone to please let us know for related questions po. No, our Zoom chat box and comment section are still open to take your questions and concerns relative, of course, to our learning sessions for today, because our resource speaker will discuss the questions later in our open forum. So just please let us know po through the available avenues for questions. All right, are we ready? All right, again, kindly follow po our Zoom name format. Meron pa po akong mga ilan-ilan na nakikitang hindi pa po nagpo-follow ng correct name format po natin. I would like to reiterate again and remind you all to please follow the correct Zoom name format for you to be able, especially to be qualified po, no, to be part of the list of the winning participants for batch 2. Ayan. I think I am seeing 1, 2, 3, 4, 5, 6. Oh, marami-rami pa po. So again, kindly follow na po our correct Zoom name format, and that is your LGU name _ your full name. All you have to do po is to click participants and then locate your name, click more, and then click rename. If you would like our secretary to assist you, please let us know again through the Zoom chat box. For our live viewers, hello, magandang umaga po sa inyong lahat. Maraming salamat po for sharing our live streaming. Thank you rin po sa mga nag-heart reacts, like reacts. Thank you very much. And for those who are yet to follow us, our official social media accounts, please do visit our official social media accounts. We have Facebook, we have YouTube, we have Twitter. No? Just please give us a follow, a like, a subscribe, for you to be able to be updated po sa aming mga training activities. I guess we are ready. Hello, attorney. Good morning po ulit. Oops. Let me just unmute po, ma'am.
Okay, hello, good morning po ulit. So, the next topic that we're going to discuss would be the protest mechanisms, no po. So, the outline of this is for the protest mechanism is the requisites for filing a valid protest and procedure in resolution of the protest. And then, of course, the blacklisting guidelines, no? Sige. Let's fix my... okay. So decisions of the Bids and Awards Committee may be protested, no, at any stage, or may be protested at any stage of the procurement process, and may be done so by filing request for reconsideration as a first step, no. So this should have been filed within 3 calendar days upon receipt of the written notice or verbal notification, but more so it's always the written notice that we are trying to resolve in request for reconsideration. So the question proceeding, no, they will submit that request for reconsideration, and then the BAC has 7 days from receipt of the request for reconsideration to resolve the issues and concerns, no, as stated in the request for reconsideration. And if the request for reconsideration is denied, the decision of the BAC may be protested in writing now, not in the BAC anymore, but in the head, with the head of the procuring entity or the HOPE. Provided, of course, that the prior request for reconsideration should have been, no, filed by the party concerned in accordance with step, no, 1, and it has been resolved in accordance with step 2, no, and this is in relation to the provisions of RA 9184. So what are the requests of filing a protest? So it must be in writing through a verified position paper, and to be accompanied by the payment of non-refundable protest fee to be paid in cash, no? So take note that the cash should be dapat ho may pondo, no? Sometimes they pay for commercial checks, but then baka tatalbog yun, no? So make sure that these are in a form of the tenders that are allowed under the rules, which is usually cash, what is this? Cashier's check, no? Manager's check, pwede po rin yung mga yon. And should have been accompanied by a certificate against forum shopping, no? That they are not filing cases over another in other venues. So that is the gist of the certification against forum shopping. And it must be addressed to the head of the procuring entity. It must be filed within 7 days from the receipt of the BAC resolution denying the RR or the request for reconsideration as we have stated here in step 2, no? And so ano po ba itong verified position paper na ito? So ito po siya. So it must contain the bidder's name and the office address. Ano po ba yung project na yan na or kontrata na tinutukoy, no? And then it must also state kung sino yung procuring entity or even the implementing office. And then of course, the brief statement of facts such as ano ba yung prino-protest niya na decision ng BAC, no? Usually mga ano po ba yung usual na prino-protest ng ating bidders, like for example, may mga hindi na open na papel nila during the bidding, like for example technical documents, ayan nag-MR sila, or for example during bid evaluation, no, where it was determined that it was read during the bidding, during the opening of bids, that they are the lowest, but then when they rendered the evaluation, hindi pala sila, so it can also be protested, no, or if it has been denied by the BAC, of course. And then the third one would be in the post-qualification, di po ba, where they were disqualified for one reason or another for not complying, no, with the agency's technical specifications. Usually, yan lang naman ang requirements for disqualifying, di ba? If they did not comply with the minimum agency's specifications in terms of what was stated in the Philippine bidding document, no? So what are the issues to be resolved? Like, for example, the bidder believes that he has complied with the technical specifications, no? But then upon review by the BAC, hindi naman pala during the bidding. Or for example, during post-qualification, they insisted, no, that based on the submission, dapat yun ay complied and on the part of the evaluation of the BAC through the assistance of the BAC TWG or the BAC Secretariat. Sometimes no, they assist also in some of the proceedings, and the issue no that must be resolved should be stated clearly in the like for example, dinenay ng BAC yung RR, yung request for reconsideration nila, and other matters and information pertinent to the relevant to the proper resolution of the protest. And then of course yung sinabi kanina that it must be accompanied by a certificate of forum against forum shopping. Okay, so clearly the position verified position paper is akin to an affidavit that in the verified position paper it must state that the affiant has read all the contents and what was stated therein, no? The allegations that therein as stated are true and correct in accordance with his personal knowledge or based on authentic records as he has submitted, no, or based on what he has submitted during the bidding itself, no. So ano po ba yung effect if the position paper is unverified, no? Kung unverified ang isang position paper, ano po yung effect? It produces no legal effect, and it will result to outright dismissal of the protest. So this is very, very important because we don't know if he has even filed other cases, no? So on the part of the Bids and Awards Committee and you as procurement organization, mga MLGU, any unverified position paper or will be considered non-complying with the requirements of the law and shall be dismissed outright. And the failure to comply shall not be curable by mere amendment of the verified position paper, as when, for example, deninay mo, no? And then later on, nag-submit siya ng another verified position paper na meron ng certification against forum shopping, o ayan na. So hindi niya i-cure. So okay, if you look at this process flow, visually you can see that if there is denial of the request for reconsideration by the Bids and Awards Committee, magfa-file na siya ng protest within 7 days, di ba? And as we said, in the form of the position paper as stated and we have discussed previously in the slides, no? And the payment of non-refundable protest fee, which should be in the form of legal tender that is acceptable by government rules and regulations. And so after receipt of that or filing of the protest with the hope shall resolve the protest within 7 days. So of course we know that the hope naman will not do it by himself, no? He can be assisted also by the Bids and Awards Committee or other committees or other staff of the office, no, that he can which is to assist him in the resolution of this protest. It must be within 7 calendar days. So when we say calendar days, diba, it includes Saturday, Sunday, kung ano po yung nakakalendaryo, no? So Saturday, Sunday. So the hope must also be mindful that when he resolves, no, kung malapit na talaga yung deadline, like for example Friday, no, and then magdi-deadline ng Sunday, so might as well gawin na niya ng mas maaga, no? And then the head of the BAC Secretariat, of course, shall furnish the bidder with a copy of the decision within 7 days from the date of the receipt of such decision by the procuring entity, no? So of course, after this protest, it has been denied by the procuring entity or the head of the procuring entity. There's still a resort, no? Or there's still another layer where where the supplier or the contractor or the aggrieved who is the aggrieved party, no, to that decision can also look into, provided of course that the protest must be resolved before any award is made. And court action talaga yung magiging next after nung protest na yan. And it may be resorted to only after exhaustion of all the administrative remedies, meaning he has undergone yung meron siya talagang request for reconsideration that was submitted. It was decided upon by the BAC, and then he has submitted a protest with a hope verified position paper containing the correct certification against forum shopping and denial by the head of the procuring entity. So non-compliance with this will mean be a ground for dismissal of the action for lack of this jurisdiction. And there have been various decisions that were decided upon by the Supreme Court where yun nga sinasabi nila na dapat ho i-exhaust muna nila yung administrative remedies na ito before they can even go to court. Kasi minsan no, they don't even protest and then they go to the regular courts. And yun, very, very important to for the supplier to comply with this doctrine of exhaustion of administrative remedies. And what is the effect if the protest was not verified and the protest fee was not paid? Then the respondent or any bidder will be considered to have failed to avail of the correct protest procedure before it filed its petition for annulment of the award before the RTC. Magkano naman po kaya ang protest fee? So ang protest fee po natin is 0.75% of the ABC, mataas din siya, 50. So kung malaki yung project, malaki din yung babayaran nila ng protest fee. So more than 5 billion, 1%. More than 2 billion to 5 billion, 5 million pesos. 1 billion to 2 billion, the 0.25 of the ABC. 500 million to 1 billion, 2.5 million. 100 million to 500 million pesos, then 0.5% of the ABC. And then more than 50 million, 500,000, and 50 million and below, 0.75. So parang yung rate niya is really, kung titingnan mo, mataas siya, So I would assume that the protest fees are provided so that kung sino po talaga yung well-meaning na mga if they really feel that their position is clear, position is really strong, they will pay the protest fees, Okay, so this is our process for the protest mechanism. We have now the knowledge check, Ma'am Monique.
That's right. Thank you very much, Attorney. Let us have our first knowledge check question under our second and final learning session. And the question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest. It becomes a justifiable basis for the hope not to entertain a protest. Is this true or false? Again, please answer through our Zoom polling feature and of course through our comment section. I'm seeing 20% participation in our Zoom box. Again, the question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is this true or false? Quick announcement lang po, if you would like to be part of the official list of our participants, you may still join us because our succeeding batches po, the slots for succeeding batches are still open. All you have to do is to register through the link that is posted by Billy Bayong in our comments section. But of course, for all of you who have been with us since Monday, we thank you all very much for joining us through our official Facebook and YouTube live streaming. I'll be closing na po the poll in 5, 4, 3, 2, 1. When we have the results, please. There you go. We have 95% who answered true, while 5% po who answered false. Attorney, tama po ba?
Of course, the answer is true, no? The non-payment of the protest fee will not toll the prescriptive period kasi kailangan pa rin siyang magbayad, and jurisdictional din po yung period to submit the protest, no? So, true po yung sagot natin.
Thank you very much, Attorney. Again, the correct answer is true. So at this point, let us now proceed with the lecture discussion. Back to you, Attorney.
Have you ever wondered how sharing of issued blacklisting is easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed, and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
Hello, please allow me to share the screen. Thank you very much for bearing with us. Sometimes, no matter how we prepare, no, may hitches pa rin in the digital infrastructure. So, okay, allow me to discuss the uniform guidelines on blacklisting, no. So this is our last topic already, no. So this is provided under GPPB Resolution 40-2017, and it has approved, no, in this resolution, no, the GPPB has approved the revised uniform guidelines for blacklisting of manufacturers, suppliers, distributors, contractors, and of course, consultants. And it was approved, no, on December 21, 2017, and became effective on September 4, 2018, after all the publications were completed. And there's also an issuance related to this, is 14-2020 on June 25, 2020, which became effective, no, on August 7, 2020. So, ano po ba yung blacklisting na ito? So, lagi natin nadidinig po ito, no? So, blacklisting is a penalty disqualifying a person or an entity from participating in any, take note, any government project for a given period of time. So why given period of time? Because it could be 1 year for the first offense, or 2 years, no, for the second offense. Depende po yun. And it's an administrative penalty because the Hope can approve this, no, for its implementation. And a blacklisted entity who was disqualified a reason or another by an agency, no, is and will be included in the GPPB CBR, o ating consolidated blacklisting report. Ano naman po yung suspension? So suspension naman is an interim penalty. So ano bang ibig sabihin ng interim? So it is provisional, no? It is imposed for infractions that are committed by a bidder during the procurement stage, na whereby prohibited siya to further participate in any bidding process of an agency. Remember, no? Suspension is interim. It is only applicable to the bidding process of that agency, and shall be effective during the period of motion for reconsideration and or appeal, and shall terminate upon the final decision by the hope or appellate authority. So minsan, there is a misnomer na pwede kang ano ng suspension, yun ang penalty in itself, no? But then na pwede mo siyang isubject lang siya within your agency, and then you no longer issue blacklisting. Hindi po yun, no? Iba po, kasi within the process, while the process is ongoing and it's an interim penalty, and since it's applicable only to your agency, it's only a suspension. But then of course, when the hope has decided with all this in the process of blacklisting, once it's blacklisted, lahat po ng government procurement, hindi po siya makakapag hindi po siya makakapag participate in any government project, no? Sige. So, sino naman si appellate authority? So, it can be the department office or government exercising general or administrative supervision over the blacklisting entity. Department level agencies shall also exercise yung appellate authority over such offices under their jurisdiction. And blacklisting decisions of government agencies that are not subject to any administrative supervision or control of any agency shall be final and executory, no? So depende ho sa anong structure po ng organization na yan. So ano naman po yung delisting? Ito naman po yung kunyari natapos po yung blacklisting period for that given period, no? Then matatanggal na po siya sa CBR, and it shall be automatically the blacklisted entity shall be automatically delisted after the period of the lapsing of that penalty, no? So ano po yung coverage, no? Where shall it be applied, yung scope po ng blacklisting na ito? So for individuals, of course, or sole proprietorship, syempre sa bidders and their spouses. Sa partnerships, so bakit pala spouses? Maybe because conjugal yan, no? Property. Partnership, no? Partnership itself and its partners, no? Thirdly, cooperatives, no? The cooperative itself, yung members of the board of directors, the general manager or chief executive officer usually of that cooperative. Paano naman po kapag partnership or joint venture or consortium? Or yan. So or has blacklisted members po yung partnership na yan or consortium, as well as person or entity who is a member of the blacklisted venture or consortium. So kung sila po ay mga partners at na-blacklist sila at nakipag-consortium siya sa iba, hindi po pwede yun, no? And in case of corporation, a single stockholder together with her relatives up to third civil degree of consanguinity or affinity or their assignees holding at least 20% shares, no, therein, its chairman or its president. So if you notice dito, yung controlling interest will also be the controlling interest will also be considered, no? Okay. So we have a knowledge check, Ma'am Monique.
Now for our second and final knowledge check question. Please drop your answers through the Zoom chat box because we will again be giving a special token to the first participant who shall correctly answer the question. Again, reminder for you to qualify po as our knowledge check winner, you need to be the first to answer the question correctly. You have to have the correct Zoom name format and you have not been selected yet po as a participant winner in our previous learning session. So let us flash our question. The question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during the competitive bidding stage whereby such contractor is prohibited from further participation in the bidding process of an agency. Is this true or false? Again, please answer through our Zoom chat box. Again, the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage whereby such contractor is prohibited from further participation in the bidding process of an agency. Is this true or false? Can I have 100% participation, please? Last na po ito. Tama po ba? Alright. Sige, attorney, let us reveal po what is the correct answer po for our question.
So ano po yung poll nila? Patingin po. Parang hindi ko nakita yung sagot nila, ma'am.
For this time po, attorney, sa Zoom chat box po sila
Okay. So may mga
answer of
B, may A.
Yes,
Yeah,
majority
okay.
po, I think, is B.
Naku, nagkalituhan na ata yung sagot nila. Kasi nga tama naman na interim penalty naman yung blacklisting because it is to be for some time lang naman siya, no? 1 or 2 years. However, ang tamang sagot po dyan ay false kasi nga hindi po siya interim. It can only be imposed upon if there is a decision by the head of the procuring entity. So may final decision po siya. So hindi po siya interim penalty. As I was explaining a while ago, the interim penalty is on the suspension. Okay? Sige po, let us continue. Sige, so you have 2 blacklisting procedures. One during the procurement stage and secondly during the contract implementation stage. Sige, medyo mahaba-haba ng konti. Please bear with me, no? So the grounds for blacklisting during the procurement stage are many, no? So number 1, submission of eligibility requirements containing false information or falsified document during the procurement stage. So ano po ba yung procurement stage, di ba? Until issuance of the notice of award, no? So kung nag-submit siya ng eligibility documents, so ano po ba yung eligibility documents? The eligibility documents refers to your platinum PhilJobs registration, yung mga yan, no? Mga tax clearance, no? So if it has been determined that false or falsified, and I have said a while ago in my previous discussion that we have found, no, some tax clearances that are pinalitan lang yung kanilang number, no? So it was found out not to be correct. So meron pa ring mga nangyayari, nakababalaghan sa mga dokumento, although if parang kung titigmanan mo, parang very legit in its face, no? Ang gagaling nilang mag-falsify. The other one is the second one is the use of one's name, no, or using the name of another for purposes of bidding. So ako, for example, and it's very rampant talaga, no, in infrastructure projects ang mga to, whether they admit it or not, no. Kaya lang sabi ko, medyo we have to prove that there is indeed the use of one's name, no, and you need a lot of documents to prove it or other circumstances that would prove this. Like for example, si A pala, contractor A, or si contractor A using yung contractor B because first of all, wala siyang SLCC, hindi na na-meet yung required SLCC, so gagamitin niya yung iba, no? So the better thing to do sana sa mga ganito, if they're really keen on joining the project despite kakulangan of their experience, would be to do it in the legal way, like joint venture agreements. Okay, the second one is the submission of bids
that contain false information or falsified documents. So it's all about falsification or concealment of information in the bids in order to influence yung outcome ng screening or yung mismong public bidding. So other documents. So the first is your eligibility. Maybe the other one is for other technical documents as submitted, or maybe even financial documents. The fourth one is withdrawal of the bid or refusal to accept an award or enter into contract without justifiable cause after na-determine na nga siya na LCRB, di ba? Or highest rated responsive bid siya. Tapos later on, bakit hindi niya tanggapin, no? So in this case, it's also a ground for blacklisting. Kasi nga, if without justifiable cause, hindi niya tinatanggap, marami kang nasasayang na oras, no? On the part of the agency. The fifth one is the refusal to clarify or validate in writing its bid during post-qualification. So part of our functions, the functions of the procurement organization, usually the technical working group, is to conduct PQ, no? And when they conduct PQ, nagka-clarify tayo in writing, but then the bidder refuses to heed on the request for clarification within 7 days. So yan din, no? Minsan baka mamaya, sinasadya na lang din, no? Because nagkabayaran na yung mga ganyan. So there are things that we have to check in relation to this one. And then the sixth one is the refusal or failure to post required performance security within the prescribed time. So you are allowed to, the bidder is allowed to post within 10 calendar days ba yun, to post yung performance security upon notice, no? And if he's not able to post yung performance security, no, then it's again a reason for blacklisting. The other one is unsolicited attempt by the bidder to influence the outcome of the bidding in his favor. So maraming ways of attempt to unduly influence, no, yung outcome of the bidding. Paano ba yung isa pa yung yung contact, no? Pinipilit nilang makipag-contact, no, sa or to communicate in relation to the bidder, or they're trying to influence, no, the outcome of the bidding. And also other acts that would defeat the purpose of bidding, like very rampant ito, no, habitual withdrawal from the bidding or submitting late bids, no. Talagang sinasadya nila ay, I've seen submission of late bids na nasasadya talaga, or minsan, no, pinpunit nila yung ibang dokumento kapag nagkausap-usapan na, no. So if you notice, and so it's very, very important that we have to really note kung sino yung mga habitual withdrawers, no? Sino ba yung mga laging nag-withdraw? And if it's determined that kung may naglalagay sila doon, ang lagi nilang sinasabi pa nga dyan, di ba? That we have no, because of lack of material time to prepare the bids. But how can that be, no? Because we have already 12 days in between. So, paano nangyari yun na lack of time daw? So, minsan yan na lang ang yun na lang ang nirarason nila. But if you see the same pattern of information, or that the same pattern of justification, no, it becomes now really unjustifiable. Okay, ano po ba yung sanction natin for blacklisting? Of course, bid forfeiture, no, security forfeiture, and then lalo na if it was kung ang kanilang bid security ay in a form of surety bond, which you can do, no, which you can call on demand. Kaya nga sabi natin yung ating bid security should be callable on demand. Pwedeng cash, di ba? Manager's check, cashier's check, irrevocable letter of credit, no? And very, very important to really check. But then if it's no bid securing declaration, then there's also an indication there that they will a statement there in the bid securing declaration that they will be subjected to blacklisting for the first blacklisting, no, kung sakaling may hindi sila na follow. And if so, then on the first offense there's a blacklisting or na pwede for 1 year, blacklisting for 2 years kapag sa second offense. And of course, the fourth one is the enforcement of the bid securing declaration. And these ones are, you know, without prejudice really to imposition of kung may mga administrative sanctions pa na tinitignan, no, in relation to other also laws that are that can be, no, that can subject the bidder for criminal prosecution. Okay.
So ito yung procurement stage visually. So ito ay may action, no? So there is an act uh, um, to file, no? To file the blacklisting process against the bidder, and can be initiated by another prospective bidder, by an observer, kasi di ba natatandaan niyo yung role kasi ng observer, kung may na observe siya that are not in conformity with the rules, di ba? He can put it in writing, no? So if you notice, kung makikita nyo na meron namang allegations doon, then it can be also an action that would be initiated. So the third one, of course, is the back, kung na makikita mo naman during the opening of bids or during the procurement process. So the back will notify the contractor in writing on upon the verification of the existence of the ground. So i-check niya yon kung the grounds that are stated there are valid. I-verify niya yon. And then, of course, an indication doon sa notification po, nakalagay din po doon that you have the opportunity bidder to show cause why you should not be blacklisted, and then a hearing will be conducted upon request by the contractor if he so desires, no? And what are the consequences of being suspended and blacklisted? So these things should be indicated in that notification to the contractor on the action that was initiated as against him. And then the contractor shall submit its written answer to the back with documentary evidence, of course. And if he so desire, no, kung gusto niya, magre-request din siya ng hearing within 5 calendar days from the receipt of the notification. So take note dito na walang extension na i-allow in this case. There's no extension that will be allowed. So if the contractor does not submit answer, di ba? Remember kanina, sabi niya dito, magsasubmit siya ng answer. So, kung sakali, walang time extension to be allowed. So, magsasubmit siya within the, with all the documentary evidence. Now, if he does not submit answer within 5 days from the notification from the back, then magre-recommend si back for the suspension of the contractor and forfeit the bid security, no? And within 15 days from receipt of the back of the resolution and records of the back proceeding, the hope determines the reasonableness of the cost, no? Or reasonable cost to whether or not proceed with the blacklisting, no? So kung sakaling, is it with reasonable cost? Yes, then it will issue the suspension order and forfeit the bid security, assuming, of course, that the bid security is in the form of cash, no? Cashier's check, what else? Irrevocable letter of credit, and surety bond which is callable in demand. Now, if the hope determines na hindi naman there is no reasonable cost, then the case will be dismissed, no? Okay. So what if the contractor submits answer? So magsasubmit siya. And then sasabihin niya, magre-request po ako ng hearing. So, syempre i-grant ng back kasi nakalagay naman doon sa rules. Kung wala naman siyang request ng hearing, no, the back will now determine who is at fault, no? And then the back sets the date and hearing time. So maghi-hearing sila. Kung naman the back, so kung nag-request siya ng hearing, magsiset ng hearing. Pero kung hindi, the back will now proceed immediately to determine who is at fault. So, meron bang fault si contractor based on the complaints and answers and evidences that were submitted? Then the next process will follow. So, syempre, yung hearing dito is non-litigious in character, no? So, hindi naman siya parang super na parang nag-ano siya sa court, no? And should be terminated within 5 days. And the back may also invite representative from a duly registered private sector group, no?
or discipline relevant to the procurement at hand to observe yung hearing na yan. Okay? So, may hearing dyan. Kung hindi naman, i-determine na ng BAC if there's an existence of fault. No? Okay, next. The BAC then, so after determining the existence of fault, no? The BAC recommends to the HOPE yung suspension ng contractor in the forfeiture of the bid security. And within 15 days from the BAC resolution and records of the BAC proceeding, the HOPE will now determine the existence of the reasonable cause. Kung oo, then pwedeng suspension order. Kapag hindi naman, then dismiss the case. No? So the notice of decision will be furnished to the suspended contractor, no, immediately upon its promulgation. So ano po yung epekto nun? The contractor is suspended upon receipt of the notice of decision. And then, the suspension shall remain in effect during the period of motion for reconsideration and shall terminate upon reversal of the decision of the HOPE. So for example, na-suspend siya pero na-determine ni HOPE na wala siyang kasalanan, then i-reverse yun. If no motion for reconsideration is filed naman, the decision shall become final and executory, and after the lapse of 7 calendar days from the receipt of the notice of the decision, mag-i-issue na si HOPE ng blacklisting order to the contractor. So if you notice, yung mga ini-issue dito are mere suspensions, di ba? May mga, the BAC recommends for the HOPE to issue suspension. So mag-i-issue si HOPE ng suspension order if there is a reasonableness of the cause of action as against the contractor. So wala pa yung blacklisting order dyan, suspension pala. Okay. At this stage, kung magfa-file siya ng motion for reconsideration and appeal, so sino pa yung magfa-file siya ng MR doon sa decision ni HOPE to dismiss, di ba? For example. So, the HOPE resolves the motion within 7 calendar days upon receipt, no? Within 3 calendar days from the receipt of the notice of decision, it can actually file MR on the basis that the decision does not conform with the evidence or there is a newly discovered evidence. No? So, ito, i-resolve niya yung motion within 7 calendar days upon receipt. And then, kung ano pa rin, kung denied pa rin, then there is still an area where they can now file for appeal, di ba? So, if he does not appeal on the decision or on the MR, kasi di ba, ina-appeal niya yung MR dito eh. Ito naman, in-MR niya yung decision, di ba? Yung suspension, for example. Now, nag-file siya ng appeal. The appellate authority resolves the appeal within 7 calendar days. Kapag hindi naman siya mag-file ng appeal, then there is already the final decision to issue blacklisting order. So yun, very, very important. Or if the appeal is not granted here by the appellate authority, then the HOPE still issues the blacklisting order. So yun, you can go back dito sa proseso na ito when you are confronted with this, because of course when it's your first time, no, you will have all those you get confused of all the process, but this is very, very, the process here that was stated or discussed or even visually presented, napakalinaw po kung ano po yung pwedeng gawin ng procuring entity, no? Okay. Ano naman po kapag ka blacklisting during contract implementation stage? So ito yung procurement stage pa lang siya. Kapag naman po contract implementation stage siya, meaning ito na po may kontrata na. So the failure of the contractor due to his fault or negligence to start. Then na-issuean siya ng notice to proceed, hindi naman niya ini-start, no? Yun. Secondly, hindi nga talaga faithfully and fully complied yung contractual obligations niya for a valid cause or without a valid cause, no? Or Failure of the contractor to comply with lawful instruction of the procuring entity pursuant to the implementation of contract. So ano po yung example? Sorry. Napindot. So ano po ba yung example nito na failure to comply with the instructions? So ang example nito would be, sinabi mo doon na meron kang technical personnel and you in fact indicated it in the organizational structure in the key personnel requirement which you submitted as part of your technical documents, no? And then hindi naman niya in-employ. So sasabihin ni agency sa kanya, contractor, pwede mo na bang i-employ yung competent engineers and technical people, no? Or even if nag-employ siya, hindi naman yun yung tamang tao, no? Yan. Ano ba bang example? Dapat ho maglagay po kayo ng warning signs in barricades under in order to have, to ensure that the ano is safe, the construction site is safe. Hindi pa rin siya, no? Contractor, pwede ka bang mag-stockpile doon sa areas which are safe para ho maayos siya at yung mga debris that will be, removed from the construction site maayos as part of your safety of the employee, no? Hindi pa rin niya ginawa. Sabi niya, sinabi mo dito na ang key equipment mo ay isang bulldozer or isang backhoe tapos wala ka pala, no? Yung mga ganyan. Or yung mga needed equipment are not there during the construction or contract implementation. So yun. What else? Dapat ho, i-renew mo yung performance security mo kasi nag-lapse na, because na-extend yung contract because of a valid cause. Tapos ayaw niya namang gawin. So these are grounds that we can see, no, from the side of contract implementation. Number 3 is the assignment and subcontracting of any contract or partner of or substitution of the personnel which hindi naman ho niya nilagay, no? And without proper written consent of the procuring entity. So in this case, hindi ka pwedeng basta magpalit because it's part of your technical documents are part of your contract, and it's very, very clear from the tenor of the contract na lahat ng mga bid submissions niya will be part of the contract such that there is a revision or amendment or amendment or revision of all that key personnel and equipment na ilalagay niya doon, then he has to comply with that, no? Sige. The next one is that kung nyari unsatisfactory yung progress niya doon sa delivery ng goods at inferior pa yung mga quality of goods na binigay. Of course, based on the agency's technical specifications, no? You cannot demand certain specifications from your supplier which is not included in your technical specification, no? Hindi pwedeng, ay gusto ko mas high-end na computer, ganito naman yung nandyan sa technical specifications mo and part of the contract, okay? For procurement of consulting services, kung very poor yung performance ng consultant mo because of his fault or negligence, sa dami kasi ng kanyang ng kanyang engagement na hindi mo nakita, di ba? Hindi nakita ng back or hindi nakita ng agency, kaya siya naanuhan ng kontrata. Because remember also that in consulting, we also have some criteria, and your workload capacity can be one of the criteria, no? So because of that, nagkaroon ng poor performance si consultant. Magaling pa naman sana si consultant. For infra naman, syempre kung very poor yung contractor or yung unsatisfactory yung quality of services, yung progress of work niya, and you can determine that there is a fault or negligence in as reflected in the CPES rating sheet or other performance monitoring system ng agency. So lumalabas talaga na hindi maganda yung workmanship niya, ganyan. Okay? What else? Of course, willful abandonment, talagang sinadya niya, very deliberate, no? He abandoned the work or he did not perform the project or contract. That's why there is a breach, and the breach is substantial and without lawful cause or just cause. So minsan yung mga contractor, ina-abandon na lang, and for one reason or another, sasabihin nila wala daw kapital, no? Ay, naku, anyway. If in case it is determined prima facie that the contractor has engaged before or during implementation of the contract unlawful deeds and behaviors relative to the contract acquisition, no? So dapat ho, if he has, did he or was he awarded the contract without using any force, mga unlawful deeds and behaviors, and if so, there is a possibility for blacklisting if proven to be true, no? Okay. So ano yung sanctions naman during contract implementation stage? Of course, yung performance security forfeiture, blacklisting for 1 year kung offense 1. Kung offense 2 na siya, talagang blacklisting for 2 years without prejudice also to other administrative sanctions and maybe other for example, di ba, kung finalsify niya yung mga dokumento. Okay? Okay. Upon termination of the contract due to the fault or unlawful acts of the contractor, now mag-i-issue na si Hope ng blacklisting order, no? So, na-terminate na yung contract, mag-i-issue na si Hope ng blacklisting order. Kung naman, contract termination is hindi feasible, no? And sometimes, yun, may mga instances talaga na hindi feasible. For example, talaga, prior year project siya, no? Masasayang yung pondo niya, no? Minsan ganun eh. Yun ang restriction talaga ng agency to blacklist, no? When the funds, we can no longer have the funds, or kung iba-blacklist mo, hindi na talaga matutuloy yung project, you will have to repropose it, no? Yung mga ganyan na considerations. So, if kung talagang hindi na talaga pwedeng ma-terminate yung contract, but the contractor committed acts or causes which may constitute ground for blacklisting, the implementing unit shall, within 7 calendar days upon the lapse of the project duration, cause the execution of the verified report with all evidences attached. So, ano po ba ito? So, tingnan natin po yung proseso niya, no? Notice of blacklisting, show cause, and decision. So, what happens in between these processes? So when you issue the notice of blacklisting, or when the agency issues the notice of blacklisting upon recommendation by the implementing unit, kasi si Hope naman magla-blacklist siya based on the initiation of action by the implementing unit, kasi sila naman ho yung nag-i-implement ng project. And by written notice, nakalagay dito, ano po yung acts na yan? Ano ba yung grounds? Mag-explain ka, contractor, bakit hindi ka mabablacklist, at kung sakali ang cost ng blacklisting ay magiging ay ganito, hindi ka pwedeng makasali sa ano ng gobyerno, di ba? Yung mga ganyan. And shall be accompanied by the verified report. Meaning ito po kasi, di ba, bago naman ho makarating kay Hope ito, di ba, may mga verification process pa na gagawin sa implementing unit, no? There are other, for example, they have verified na for some time talaga, slippage siya for 5%, slippage siya for 10%, slippage siya for 15%, mga ganyan. So these are part of the facts that you have to determine, no? And then second one is the show cause. Sasabihin niya, hey contractor, within 7 calendar days from the notice of blacklisting, magsasubmit siya ng position paper. Bakit ka hindi mabablacklist, no? At kung sakaling hindi siya nag-submit either by inaction or by default, no? Hindi ka pinashowcause ka within 7 days, within 7 days hindi ka nag-comply. So we've seen, in our experience, you have seen people who do like this, no? Kung maaano na sila, kung may blacklisting na sila, sa order na sila, saka pa lang sila yung mga ganyan, no? But then, the Hope shall issue the blacklisting order if there is an inaction or maybe default on the part of the contractor. Okay, the third one na is the decision. May decision na. Within 10 days from the receipt of the position paper, the Hope will decide iba-blacklist ba si contractor o hindi. And it shall serve the written notice to the contractor on his decision after the lapse of 7 calendar days from the receipt of the notice of the decision. So, check natin kung talagang may 7 days na, ibig sabihin pwede na talagang ano, no? it becomes final and executory na talaga. So in summary, when does the blacklisting order become final and executory? So number one, hindi siya nag-file ng MR doon sa decision at nag-lapse yung decision na yan after 7 calendar days from the receipt of the notice of decision. Okay. Nag-file siya ng MR at na-decisionan pero hindi siya nag-file ng appeal, no? So na-deny yung MR niya pero hindi siya nag-file ng appeal. So executory siya after 7 calendar days. Na-deny yung kanyang nag-appeal siya, na-deny, then the decision becomes final and executory upon receipt by the agency concerned of the decision in relation to the protest. Okay? So ano po yung status ng isang blacklisted entity? Ang mangyayari dyan, pwede siyang, kung before the issuance of the blacklisting order, pwede siyang mag-participate except doon sa agency where he is suspended, no? So if you notice, in the issuance of the suspension order, there is really, may kaakibat siya, no? Na mention talaga. Kaya lang some agencies really do not follow yung proseso na yun. And then the blacklisting order is issued before the notice of award. The blacklisted entity shall not be qualified for award. And such project shall be awarded to another bidder kung before the issuance of the notice of award. Ngayon, after the issuance of the notice of award, syempre hindi na ma-prejudice si bidder or si contractor doon sa order, no? Provided that the offense is not connected with the awarded project or contract. Okay? So, how do you apply yung penalty? So, kunyari may previous blacklisting order siya, tapos may 2 years siyang blacklisting order. 2 years, kasi 2 years, di ba? Then, the latter shall be deemed terminated in subsum. So, meron siyang remaining pa na blacklisting order plus 2 years. So, 2 years yung kanyang blacklisting order. So, kung more than 3 naman, 2 years pa rin yung kanyang blacklisting period, no? Okay. So ito po yung form ng blacklisting order form pursuant to GPPB Circular 03-2020. Maliit po siya, but if you notice, you can check it from the downloadable forms and this should not be modified. So medyo maliit siya, hindi natin masyadong mabasa. But here, you can see, and I'm sure GPPB will provide you with the presentation where you will see where the link where you can download the form, no? If you are confronted with this decision. So ito po yung form, ano po yung order ng board or board resolution number, ano yung complete registered address, license number, AMO, ano yung pangalan ng project, saan located at anong amount, ano yung offenses na specific offenses that are committed, ano po yung sanctions that will be imposed, like blacklisting ba siya, 1 year, specific duration, ilalagay yung date, and then of course yung issuance of the order of blacklisting, no? Kasi within 3 days, di ba? Okay. Sige. So the online blacklisting portal as part of our presentation is issued under GPPB Resolution 14-2020, no? In June of 2020. So ito po is an electronic facility which allows which was developed by the GPPB TSO, and ito ina-allow niya yung procuring entity to post the blacklisting orders, mag-update and i-access yung information related to agency blacklisting. So ito po ay and this was developed, no, at that time corona 2020 and pandemic yan. So of course, the blacklisting orders must be posted and posted and encoded in the OPB. So, meron tayong online blacklisting portal, alternate user ba yung tawag doon? Or he is the one authorized to kalikot, no, na maglalagay doon sa OPB, no, and it should be within 3 days from the date of the effectivity, which is why dito sa ating blacklisting order, no, Very important that we put the date kasi ang effectivity niya. And in case of a lawful order from a judicial or quasi-judicial body directing temporary lifting of the period of suspension or remove the name of the blacklisted entity, then it will be removed in the meantime or while the case is pending, no, kung merong order po ng judicial body or quasi-judicial body. So upon the lapse of the temporary lifting order, the procuring entity, ibabalik po niya at i-repose niya ulit yung name ng blacklisted entity doon sa CBR. So upon reposting, the procuring entity or alternate user, yeah, the one that is using it, the OPB is called the alternate user, the official or the alternate user shall adjust the period of suspension doon by adding the number of days the suspension of the blacklisted entity was lifted or removed from the CBR in order to fully serve yung 1 year or 2 years penalty as the case may be as indicated in the blacklisting order, no? Sige. So the period of suspension imposed upon the blacklisted entity shall not be diminished by an order temporary lifting the order of suspension. So yung total pa rin niya na period, yun pa din yung magiging applicable. So okay ma'am, last na po ito ata na knowledge check natin, and this is our last presentation. So thank you very much everyone for listening. Ma'am Monique.
Thank you very much, Attorney. Before we proceed, we would like to announce po, of course, our knowledge check winner for today. Congratulations po, Sir Eric Santa Romana from LGU Pinamalayan Oriental, Mindoro. Congratulations po, sir. Again, please check out your chat box for the details needed for you, of course, to be able to claim your special token. Now, to proceed with the open forum, please be reminded that questions which are initially gathered from the Zoom chat box and from our Facebook and YouTube live streaming comment section are filtered, as our resource speaker shall only be answering questions related to our learning session. Nevertheless, rest assured that all questions raised and received are documented, which shall form part of our frequently asked questions. Once again, let us have our resource speaker, Attorney Jeneline Malateo Dawayan.
Thank you, ma'am. So, meron ba tayong questions, ma'am?
Yes po, we have, I believe we have gathered 7 or 8 questions po. So,
Yes.
we will be flashing those questions po. Let's start with our first question. And ma'am, in case of conflict of interest, should the alternate representative come from the same company or organization? What are the measures in place to avoid collusion?
So I'm not, medyo naguluhan ako sa first question, but on the second question on what are the measures to avoid collusion, of course, may nakita ako na kasi ito naman is very practical. Sometimes we have a practical application in terms of avoidance of collusion. Kasi sabi ko nga, one of the hardest to prove talaga is collusion unless it has been, hindi lang iisang circumstance, but you can see the pattern, di ba? You will look for red flags like patterns of laging magkakasama o nanalo ito, laging nagwi-withdraw, yan, habitual withdrawals. Minsan yung bid nila doon sa masyadong konti yung diferensya at nagsasalitan, makita mo na nagsasalitan yung mga nananalo. So in terms of really checking avoidance of collusion, of course, this has to be also during your pre-bid conferences, di ba? Dapat na isasabi din natin yung mga unlawful practices na ito. And then what else? Also, if you notice, sabi ko nga that there are habitual withdrawals, yung mga ganyan, nagsasalitan, konti yung mga presyo na binababa sa ABC, yung mga ganyan. So, hindi lang talaga, you cannot really pinpoint a single period na sasabihin mo talaga na, a single instance how to really avoid collusion. Okay, ma'am, next please.
Thank you very much, ma'am. On to our second question. Is it possible that a family member of chief accountant or treasurer be able to participate in public bidding since they are not part of the procurement process?
Okay, maybe this is not related to my topic, but alam natin ho kasi na yung chief accountant is prohibited, di ba, under
Attorney? Attorney Jen? All right, while we wait for Attorney Jen, I would like to remind our Zoom participants po no that the link to our presentation materials for both learning session 1 and 2 is posted po in our comments, in our Zoom chat box rather, for your reference. All right, so for those who were not able to catch it, we will float it again in our chat box so that you may be able to access it. Kung hindi nyo po ma-access, please let us know. Please message us through our Zoom chat box. Let's see. Do we have Attorney Jenna po in our Zoom room? Attorney? And kung meron pa po tayong mga questions, baka pwede pa po tayong pwede pa po nating ihabol. We'll see po if we still have extra time later. Maidagdag po natin sa initially gathered available on deck. No? Thank you very much po to our live viewers. Thank you for sharing. Nagna-notify po sa amin. Thank you for sharing our live streaming. Thank you very much po. We have Ma'am Cheryl Monreal from LGU Miagao. Thank you very much po, ma'am, for joining us through our Facebook live streaming. Let's see, Attorney Jen. Are you there? And again, for those who are would like to be part of our succeeding batches po, meron pa rin po kami susunod na mga batch this next week. For if you want to join us, please check out the link in our comment section. Pinost po ni Beli Bayong sa ating comment section yung pre-registration link po. No? Just please check it out. Kung hindi po ulit ma-access, let us know po through the comments down below. Alright, so again po, we've been receiving messages po again from our live streaming audiences requesting for the presentation materials. Ayun po, as much as we would like to share it to you all, please be advised that only the official Zoom participants po will have the access to all of our presentation materials. Okay, we hope po na you understand, but you can always refer po to our recorded session, our official live streaming social media accounts. I believe we have Attorney Jen back. Hello, ma'am. Attorney Jen. All right, so I guess let us play more APPs for you to watch. And then please stand by po. Please stay with us and see you in a short while. Thank you all for patiently waiting. We just received a message from our resource speaker po, no, it's like nagkaroon po ng emergency si attorney, but for the meantime, we will be keeping in touch with her, but we commit to send and provide the answers to the questions initially gathered po ng ating secretariat to the emails of the official Zoom participants. No? But if you have more questions, you may still ask them out po by visiting slido.com. All you have to do is to just type in the FN code #governmentprocurementph, to which the GPPBTSO will answer through an issuance or through FAQs. You may also request po for legal consultation on specific concerns of your municipalities from our office. All you have to do is to visit our official website at www.gppb.gov.ph to know more po about the details, to the fuller details of the process. So at this point, we would like to thank again, of course, our resource speaker, Attorney Jenelyn C. Malateo Dawayan, for providing us a profound lecture discussion, both po yung first and second learning session natin. Now to proceed to the final reminders, allow me to provide a recap or bird's eye view of our today's learning session. So for today, we had an entire session on protest mechanisms and remedies, where we had a comprehensive discussion on the penal, civil, and administrative provisions, as well as an in-depth discourse on the liabilities under Republic Act 3019. We also had a profound discussion on the requisites for filing a request or motion for reconsideration and valid protest. Towards the end of learning session, we likewise discussed the procedure to resolve a protest. We also had a fruitful discourse on the blacklisting guidelines, where we highlighted its uniform guidelines issued by the GPPBTSO. We also discussed and identified the grounds and sanctions for blacklisting during procurement stage. Finally, we also had a meaty discussion on the blacklisting procedure during the stage of contract implementation. Both sessions are led by our resource speaker, Attorney Jenelyn Malateo Dawayan. So at this point, we would like to thank again our unparalleled resource speakers and GPPB recognized trainers from day 1 to 5. We had Mr. Reynaldo Villon of the Department of Budget and Management, Regional Office 2, Ma'am Graciela Ortiz of Department of Budget and Management, Regional Office 3, Undersecretary Gerard Chan of the Department of Education, Ma'am Junelyn Pagunsan of the Office of the Ombudsman, and of course, OIC Regional Executive Director, Attorney Jenelyn Malateo Dawayan of the Department of Agriculture. We are honored and grateful for all the time accepting our invitation and for selflessly sharing your knowledge and expertise to our participants. We do hope po, that you were all able to really have a deep dive on all of our learning sessions, and that you were able to equally enjoy our learning spree. We are in great hopes that lahat po ng mga baon-baon nating mga tanong po on specific concerns of our municipalities were answered, and that our event were able to provide enlightenment to all of you in order to fulfill your duties as efficient procurement practitioners in your respective municipalities. So at this juncture, before I proceed with the final reminders for our Zoom participants, of course, we would like to equally thank all of our Facebook and YouTube Live viewers for your consistent high spirits during our week-long virtual event. We hope to have you as our official participants in our upcoming training activities. Thank you all very much po. Ayan. So to proceed with the final important reminders for our Zoom participants as part of our requirements for the provision or issuance of certificates, again, please do not forget to evaluate our today's resource speaker by clicking through the link shared by our event secretariat in our Zoom chat. Note that your responses are editable under the Edit Your Response button for the daily evaluation of the resource speaker. Again, this is a system-generated tool, so we will be having a real-time receipt of submissions. So we will be giving you 5 minutes po to click through the link and submit your responses. Let me see our timer on our screens. And we will no longer share na siguro the list, just the timer na lang so that we know when our 5 minute is up. Thank you very much.